Ladies and gentlemen, let's keep moving with the important part. Teri Konstantiniou is a barrister on Green's list. She has given a paper, I can't think how long ago it was about wills and costs and commissions and those sorts of things. She is ideally placed. You ought to be aware that we do have a Greens library, and so if you're doing the general barrister search on the bar thing, you'll find a profile. If you then look at that profile, it'll say Greens List profile. That's sometimes a little more detailed, but it will also say on the Greens List one, if you go to the Greens Library, you can find this paper or that paper and the specific topics. And Teri has given a number of papers, and if you check her profile, you'll see that she is a very experienced practitioner. Broadly in wills and estates, she knows her way through this jungle. She's also involved in a series of mediations and specifically giving advice to trustees. Court of Appeal experience as a junior and knows her way through that jungle. Let's not talk about her, let's listen to her. Teri, thank you.
Thanks, Mitch. Good morning, everyone, and welcome. You referred to this area as a jungle. It's probably not that far from the truth, really, in many respects. I'm going to be looking at Executor's costs and commission and what reform proposals the Commission has put forward in that regard. I gave a paper, it was last year actually, and it was at the time when the Law Reform Commission announced its review, and I gave a paper on the operation of Rule 10, the Professional Conduct and Practice Rules. And at that seminar, I was firmly convinced and of the view that solicitor executors were very much in the sights of the Commission. They certainly have been in the sights of the courts, and where solicitor executors claim commission, those applications are looked at very, very carefully and scrutinised with a fine-tooth comb, as they should be. So I gave that talk, I think it was with Peter Pascoe as well, and you chaired that, Mitch. We were both of the view that we were expecting some pretty significant reforms to come from the Commission in that area, and I was a bit surprised to see that nothing much has really changed. And in terms of the operation of Rule 10, I think there was a bit of a lost opportunity. There was a recommendation for Rule 10 to possibly be included in a statutory provision in the Wills Act, and that recommendation wasn't accepted. I'll discuss that shortly. And I thought that was a bit of a lost opportunity, in my opinion. But the Victorian Law Reforms Commission's terms of reference in respect of executors' costs and commission focused on two main areas, and one of them was whether there should be special legal rules for legal practitioners who act as executors, because that's clearly an area of concern. And whether a court should have the power to review or vary costs and commission charged by executors. So that were the terms of reference that the Commission looked at in terms of executors' costs and commissions. Now, we all know that there's no automatic right to commission, so unless there's an express provision in the will, executors, whether solicitors or not, cannot charge commission and cannot charge their professional costs without a charging clause. So if there isn't an express provision in the will, you need the consent of the beneficiaries. And there's a debate about what that consent entails. And I'll speak about Justice Habsburger's decision in Smulvik and Recht, because what the sort of consent that you need to have is informed consent. And what does informed consent mean? So you've got to have the consent of the beneficiaries, and if you can't get that of all the beneficiaries, then off you go to court and you make your application pursuant to Section 65 of the Administration and Probate Act. So that's the general framework in which we operate. If you are asked as a solicitor to be an executor, you should, in my mind, play a little word association game. The minute you're asked to be an executor, you should immediately go to Rule 10 of the Professional Practice and Conduct Rules. I have extracted that at page 2 of the paper, and I won't read it out, but there are very express terms and procedure that you've got to comply with in order to ensure that you have properly advised and informed the will maker of what effect the clause in which you claim commission is going to have on the residuary estate and what effect that will have for the other residuary beneficiaries as well. I didn't get an opportunity to include this in the paper, but I'll certainly get Luke or Matt from my clerk's office to put this up on the website. But I've developed a checklist, a Rule 10 checklist, which basically goes through the Rule 10 procedure and gets you thinking about what questions you need to ask the will maker if you're asked to be a solicitor executor, and what information is to be provided and what instructions you're to obtain before those commission and charging clauses are included in the will. So I'll put that up and have that up on the website for you for your reference. It is only a guide, of course, but certainly will assist you in providing advice to your client. So the Commission looked at a range of proposals in this regard because the courts have been particularly concerned with recent claims by solicitor executors for commission. In particular, the concern was that the claims were excessive and had the practical effect of depleting the residuary estate, and that was not believed to be in the contemplation of the will maker's intention when those sorts of clauses were included. So there was a real concern to ensure that, number one, estates were not unduly depleted by excessive commission and charging claims, professional charging cost claims. But the other concern of the Commission, and this came out in the consultation papers as well that Richard referred to, there was a concern that solicitor executors were double dipping. So they were charging commission and they were charging their professional costs and calling it commission charges. So there was an understanding, or what came across was that there was a confusion amongst the profession of what constitutes work of an executor and what constitutes work of a solicitor in a legal profession, of a legal professional nature. And so the Commission considered proposals to address those concerns. In terms of the first set of proposals, what practical measures could be implemented to ensure that charging clauses and commission clauses were fair? The Commission looked at whether it was appropriate to appoint, whether it was necessary to require independent witnesses to witness a solicitor executor clause. And as Richard mentioned, the Commission found that to require an independent witness would be unduly restrictive. It would cost more because it would require the will maker to go and get another person to interpret the clause and then make a judgment about whether the will maker understands what that clause means. And why would you go to that effort if you've got a solicitor sitting right there who is able to do that? So that recommendation was, I think, quite sensibly not followed through with. And The other recommendation about whether a will maker was required to obtain independent advice before agreeing to the inclusion of a commission clause, similar concerns there. Again, requiring independent advice means getting another lawyer to give you advice about what you're going to get yourself into. You've got a lawyer there who is most likely the family lawyer and has been for many years and is a person that the will maker trusts and has confidence in. So to require the will maker to get yet another independent advice, another layer of cost would be imposed on the will-making procedure, and that was considered to be not unduly restrictive and costly, but it was seen to deter the general public from going to see lawyers to get their wills done, because it would involve them getting independent witnesses and further advice, and that wasn't considered to be encouraging. So that was sensibly, I thought, not followed through with. The next recommendation, incorporating Rule 10 into the Wills Act, I thought that was a lost opportunity. I think that the profession would benefit from having Rule 10 incorporated into a statutory provision, such as the Wills Act. I mean, the first thing you do when you draft a will is you go to the Wills Act and you ensure that all of the requirements of executing and preparing a will are complied with to ensure that the will is a valid document. So what better place to put Rule 10 to make you more aware of your obligations and responsibilities in advising beneficiaries? What better place to put that knowledge than the Wills Act? But what the Commission considered, that it was not persuaded that giving Rule 10 statutory recognition necessarily meant that the will maker would be giving informed consent to the inclusion of a commission or charging clause. The Commission in particular was of the opinion that the court was the best arbiter of whether informed consent had been given. And in particular, the Commission relied on the decision of Justice Habsburger in Smolevic and Recht. I've cited it in page 4 of the paper. But I think it's really important to read that case. And I think if you follow Justice Habsburger's decision to the letter, you can't go wrong, because he sets out the requirements of Rule 10 and then gives you some guide on how to practically implement it. In Smolevic and Recht, I won't go through the facts in detail, but the upshot was that the testator in that case was not told that there was no automatic right to commission for executors, and that he did not have to include a commission clause in the will if he chose not to. So he wasn't advised of that. The testator was not advised that in the absence of a commission and charging clause, the solicitor could make an application to the court under Section 65. He wasn't told that. He wasn't told that if the commission and charging clause was included, this would effectively mean that the executor was entitled to 3.5% of the capital and 5% of the income, irrespective of whether the work was done or not. He wasn't advised of that. The testator was not told that if the commission and charging clause was included, that the beneficiaries would be unable to challenge the level of the executor's commission. He wasn't advised of that. And he was not advised that the rates were not in fact fixed, and he could negotiate those rates with his solicitor executor. So if you don't do any of that and advise the testator of all of those matters, I think you could be fairly confident that any challenge to your commission or charging clause will stack up. You should feel fairly confident that it won't be overturned. So what the Commission was of the view about was in respect of incorporating Rule 10 that smaller vic and rect and cases like it were enough to ensure that solicitor executors were going to obtain informed consent in the terms that Justice Habsburger explains in his decision, and that there was no need to go to the extent of incorporating the rule in a statutory provision. Because if you got it wrong, the courts will fix it. The courts were the ultimate arbiters and were able to determine whether informed consent was given on the facts of each case. So they thought that wasn't necessary. We'll see how that pans out. Incorporating a new rule on obtaining informed consent into legislation, that was another proposal, and what that really looked at was modifying the existing Rule 10 to make it more clear, to make it more easy to follow, and the conclusion was that modifying the rule risked prescribing facts and matters. So it risked putting down a list of things that people would just tick off and say, well, I've done this, I've done that, without really having regard to your instructions and the particular facts that the will maker is faced with. So the Commission was concerned that to unduly restrict the rule by further defining it and prescribing a list of things would run the risk of categorising it into a box. And as we know, wills and will making and clients in will making situations, it's a very fluid area of law. Every fact depends, every matter will depend on its own facts. Testators will have their own particular family history and background. They may not be able to understand English very well. They have limited education. So to prescribe those facts and matters into the rule would just be unduly restrictive and not provide a level of fluidity that we all expect in these situations. The conclusion was that to prescribe such matters would be unwise and ignore the complexity of cases and their unique facts. At the end of the day, whether or not informed consent was given is a matter for the court to decide anyway. So the Commission didn't think there was any point in changing the rule, enshrining it in legislation, because at the end of the day, the court would determine whether informed consent was given. So I've summarised recommendations 51 and 52 in terms of revising the conduct and practice rules. The recommendation was that the Law Institute or other relevant body should revise the conduct and practice rules that apply to legal practitioners who prepare a will to expressly require the practitioner to obtain the client's informed consent. And if you follow Smilovic and Recht, you should be able to comply with that recommendation fairly comfortably. The further recommendation was that a new provision should be inserted into the Administration and Probate Act to the effect that a professional executor should be unable to claim commission or remuneration for their work unless the will maker gave their informed written consent. That's as far as the Commission thought was necessary to go in terms of enshrining the rule into law. You can't claim it unless you've got informed consent. What's informed consent? Smilovic and Recht, or the court will decide ultimately on the facts of each case. That's a framework that we're dealing with. So what are executorial duties and what are professional services? These reform proposals were considered as a measure, as I mentioned earlier, to stop what was a bit of double dipping by solicitor executors, where they charged both commission and professional charges. And the consultation papers from various solicitors who practice in the area, a lot of people said that they would desist from providing legal services to the estate. That most solicitors out there who are executors send their client or the beneficiaries off to another lawyer to advise the estate. That's what most lawyers out there, was discovered, do. And the Commission considered that that was an unnecessary and costly burden on will makers who were having to employ a separate lawyer to advise the estate. And this would also cause considerable delays in the administration of the estate. Many solicitors said that they declined to act as executor because of the obvious conflict and problems associated there. And that was a recommendation put forward. The Commission was of the view that it was not in the public interest to implement a standard policy that no solicitor could act as an executor, because, as we all know, will makers repose trust in their solicitors, family solicitors, for many years, and it's their choice and it's their right to have their family lawyer act as their executor. What better person do you trust to look after your affairs when you're no longer there than the person who has known your family and your legal affairs for most of your life? So they thought that it was unnecessary to restrict solicitors and executors in that way. What they did find, what the Commission did find was would be of most benefit, was the need for legal practitioner education and the ongoing education of solicitors where they were looking at acting as executors. And in the consultation papers put forward to the Commission, it was uncovered that there was generally a poor understanding amongst the legal profession about what costs they could legitimately claim if they were acting as executors, whether in fact they could charge commission, and the fact that they could not charge both legal fees and commission for the same work. Not many people were aware of that. And not many practitioners were aware that a clause in a will that authorises them to charge for legal work did not at the same time give them an automatic right to charge commission. So those were the main areas where the Commission found that legal practitioners lacked knowledge, experience and education. And so one way to encourage the legal profession to be a bit more aware of those issues was to be involved more in the education, conducting seminars such as this, providing guidelines, as Richard mentioned, with the undue influence guidelines, setting out the guidelines, setting out the rules, the do's and don'ts of acting as a solicitor and executor. And it was considered that if that regime was put in place, that it was a fairly confident expectation that people would understand more what their obligations and duties are and what they needed to do to make sure that all the boxes were ticked and that the will maker and beneficiaries were properly advised. The next recommendation was the law practices being required to disclose to the beneficiaries the likely costs or range of estimates of costs in the administration of the estate. At the moment, I think it's section 3.4.9 of the Legal Profession Act. We all know that. It's what requires you to provide a cost disclosure to your clients for all litigious and other matters. But the problem with that rule is there's no requirement on executors to provide that cost disclosure to beneficiaries or to the will maker. So another recommendation was to require solicitor executors to provide a similar cost disclosure, as you normally do, to the beneficiaries of an estate. Now, at what time do you do that? As soon as you are appointed executor and as soon as the administration of the estate begins, you send off your Section 349 disclosure statement. And I think that's quite a sensible approach in that regard. And again, you can't go wrong. As long as everyone knows what's being done, why it's being done and what the cost of it being done is, there should be no issue. The final set of proposals I thought were quite revealing. Court review of costs and commission. In New South Wales, the Probate Administration Act under Section 86 capital A does allow a court review of commission charges and costs, but in New South Wales, only a person interested in the estate or the court itself may initiate the review. In Victoria, the Commission considered that the review should only be initiated by interested persons and not the court. And the Commission found that, in fact, there was nothing wrong with allowing the court to initiate a review of commission charges and costs if it thought that it was necessary. So if you have related court proceedings, Mitch mentioned VCAT administration costs. If something arises out of these related proceedings that raise the suspicion of the court that perhaps there is some double dipping going on or excessive costs and charges being charged to the estate, and the Commission thought there was nothing wrong in the court initiating that review and policing that process. What it was careful, though, to note was that it was not the role of the court to monitor every aspect of the administration of the estate, because after all, that's the job of the executor or the administrator. So there was a supervisory role, but not a strict monitoring role. And that recommendation is at 57, and I've set it out there. The time limit that was recommended, that would be a time limit of 3 months from the date that the applicant beneficiary knew or ought to have known about the charges. So 3 months from that date, you have to initiate a court review of the charges if you think they're unnecessary or excessive, if the client beneficiary does anyway. That's a bit of a snapshot. And I will put that checklist up for you to have a look at and go from there. Thank you.
You can see the wealth of knowledge we have up here, or they have, perhaps more appropriately. I want to invite some questions, but having listened to Teri's learned exposition, I want to draw your attention to a clause which I had some trouble with down at VCAT, where was it? 2008. Walsh versus Cannon and others. Defendants, respondents were Patrick Cannon, Coburn and Associates, and Cannon. The clause under consideration there was, I direct that as my executors and trustees are solicitors, they shall be entitled to be paid all usual professional fees for work done by those executors. All usual professional fees. As if they were not my executors but employed. They shall in addition be entitled to executors' commission for their pains and troubles at 3% on corpus and income. I was down at VCAT because one of my colleagues in a fit of enthusiasm had regarded this as in trade or commerce, and I had Dr. Chris Hanscom against me saying, no jurisdiction, this isn't trade or commerce, these are professionals. Commission for an executor, is that a profession? Not so sure. Legal charges for a lawyer acting in a firm, that's a profession. Is that trade or commerce? Teri does a bit of retail tenancies. We are trade and commerce for retail tenancies, aren't we? But all usual professional fees for work done, what happened was they opened a file in the office, they charged every single thing on legal fee rates for everything they did, including clearing out the house, appointing the real estate agent, doing this and doing that, at legal rates. Was that work legal work? Was that legal professional work? It was charged as if it was. And having done that, they then charged 3%. This was before Smilovic. The outcome was Judge Harbison said, no jurisdiction down at VCAT, not trade or commerce, go off to the Supreme Court. We did. We settled. Some questions now. Anybody want to start the ball rolling out there? Go for it.
In relation to the costs, if you don't have a commission, are you suggesting that you can't charge anything other than for legal work undertaken by a legal practitioner, so therefore not for arranging a funeral, not for dealing with all of the problems that you have between the beneficiaries arguing about various things? How do you cover that charge?
That's a question obviously directed to Terry. Terry, would you just restate the question so it's on record and then give us an answer?
So the question, can anyone hear me? Yeah.
How do you overcome this double dipping?
Yeah. The question is, where you're charging, you're clearing out the house and dealing with beneficiaries, do you charge that at legal rates, or is there some other rate that applies? What the Commission was clear to emphasise is that there is legal work, there's specific legal work that is considered to be legal work. For example, the conveyance of real property in estates is legal work. Arranging the funeral and cleaning out property is executorial work. And what they suggest is that you have a different rate, and that's something that you need to negotiate with the will maker. There's no different scale of costs that you go to for executorial work.
Could you tell the will maker, this is the charges, these are my charges, I'm not going to discount it because I'm spending my time doing these funerals and dealing with all the family issues because you want me to do it, that's my time, and I negotiate that.
Yeah, and if that is what is agreed with the will maker, and the will maker understands that you will be charging $2.50 an hour to go and clean a house, or you're going to charge $100 for every letter that goes to a beneficiary, if they understand and accept that that is a reasonable charge for your work, then that is what has been agreed. And that is what informed consent is. And that is what the Commission is at pains to emphasise. You can negotiate whatever charges are, in your opinion, and in the will maker's opinion, reasonable.
And so your clause wouldn't say usual legal charges?
No. You would set it out. Yep. You would say, for example...
Terry, let's move on. Can I just draw your attention to Rule 10, 10.1.2, the inclusion in the will of any provision entitling the practitioner or the practitioner's firm to charge legal costs in relation to the administration of the estate. Now, whether legal costs means costs at the rate that lawyers charge for non-legal work, administration of the estate may or may not be legal work. So I think there's room for people to be sure, and I think perhaps the answer that Terry's saying, if I can encapsulate it, was you need the disclosure, you need it in writing, you need to talk about your legal charges for your legal work, you need to talk about your commission charges and have that disclosed, and if you are going to charge as an executor at any rate, but particularly at legal rates for doing what you do as administrator, organising for the skip to come, and you're going to charge at legal rates, you better have that in there too.
Yep.
Okay? Gavin, what do you got?
Where a person goes to a trustee company like state trustees or equity trustees, are those trustee companies under the same obligation to get informed consent about the commission they will charge?
I'll duck that one. Terry? Richard?
We have representatives.
Shall we ask the questions?
Paul?
Thank you very much for that notation, Richard. The trustee companies...
Can I just say, Paul from State Trustees will know his way through this.
The trustee companies, State Trustees has its own act by which its commissions and rates are enshrined. So we're controlled by that. As with trustee companies like equity trustees and so forth, they have a bit more flexibility because they are more of a private trustee company and they can negotiate those charges. We're pretty much set by legislation, so we can't move. But what we say is that there is a distinction between executors' commissions and legal professional fees, and that distinction falls between commissions which are based on the income drawn from the estate, a percentage of the income, and or any percentage from the corpus of that estate. Anything else forms a part of the administration of that estate, which estate trustees don't charge commission on. But then you have the issue of legal fees. And as far as
can I invite you, Paul? I think the question went to: do you have the same disclosure obligations in respect of your arrangements?
I am coming up to that, but what I'm saying is that because of our Act, we don't have those disclosure requirements. They're not required. As far as I'm aware, equity trustees don't, Judge Papaleo don't. If any of that work was sourced externally to a third-party law firm, yes, then that would be fine.
And it's a different question, of course, if it's a third-party law firm, then you're not acting for yourself, you're engaged to do the work, and you'd have your normal disclosure obligations to your client, which is state trustees, advising or dealing with them. Other questions? Go.
I had a similar question because one of the things that I come across quite often is the fact that the extent to which state trustees and others have disclosure in terms of just informing their clients seems to be quite low. So, for example, when I speak to my clients about executors and roles, etc., I give them a very wide understanding of it and options who can be. Whereas a lot of the times I get people who come to redo their will from their powers of attorney, and the state trustees automatically the executor or the attorney, and I'm surprised that those sort of things weren't looked at by this commission, because it is, I see in my practice that it's a really big ongoing issue.
So the question goes to whether state trustees ought to have been included in the ambit of the reform. I'm having read it, I'm not clear that they were considered as a separate group of professional actors.
They weren't for precisely the reason that Paul has identified, because it's all in the Act anyway.
Do they tell the clients that the rates are in the Act? If they want to look at the Act, they'll see what the rates are?
If you want to clarify that, we do have, as part of our engagement, we do have an information sheet which discloses all that, which is part of that. So that's all. Yeah, absolutely.
I have a question, if no one else does, which is part of what we're here today to do is to say, what's the likelihood of things changing? Because there's been the inquiry, there's been the reform, there's been the recommendation. I've lived in you, David, and say we've all seen things come in like Section 32 disclosures in the conveyancing field. We've seen the new powers of attorney produced by the New Instruments Act, the new divisions. There's a bit of warning about that. Is there anything that the panel want to say about the oh my gods? Will you find that if you've done a will in the next 3 to 6 months and there's an announcement, let's just pick a date, 1st of July next year, that says, as from now, the disclosure requirements will be X, Y and Z. I saw Jeff Shaw, charges have been dropped, so maybe the state government will be able to run the country, run the state. But presume they say we want to adopt something as at 1 July next year. Clearly it won't be retrospective, but whatever you are doing between now and then will be in the light of the recommendation having been made. Is there any obvious change in practice that either Terry or Richard would say, think about doing this now, even though it's not yet in play?
I was actually having a bit of a thought, Mitch, while sitting here, about what's going to happen when this checklist or something similar is produced by the Law Institute, because I suspect that the end result is that the recommendation in relation to checklists will be something that will be adopted. And I was thinking in relation to how it's going to impact upon liability for solicitors, both who are the will makers and how solicitors who might have acted for the will maker previously, or the beneficiaries of that estate previously, might react. And there's a couple of cases, I keep forgetting the name, Hawkins I think in 1984 and Hill and Van Erp in 97 in the High Court, made it clear beneficiaries solicitors owe a duty to beneficiaries, to third parties. So what happens if a solicitor just has someone who is showing obvious signs of undue influence, solicitor is a bit rushed, and just bangs out a will, gets them to sign up, ignores the recommended checklist that is suggested by the Law Institute, or having attended this seminar is aware that there is some sort of checklist in the offing, and they've created a will that is ultimately set aside because of undue influence. There's plenty of litigious practitioners in the community who would look at this and say, is there a claim against that solicitor for being negligent, for having prepared a will where the party showed some signs of undue influence that resulted in the estate being depleted in costs in defending the claim, particularly if you can't recover the costs against the will maker, the solicitor. So they're one of the things to look at. It's a bit of a hand grenade, really.
I like the way you phrased it as a question. What would happen if? Can you notify your insurer, LPLC? Notify early, notify quickly. They're very helpful. They're not against you. I've given this advice on many occasions. If you reckon you might have a problem, tell them. No downside. Protect your back. Terry? Quick.
Well, in terms of solicitor executors, clearly the Commission has, and courts expect that practitioners will just use common sense. Just use your common sense and ensure that you fully disclose all your costs and charges, whatever they're agreed at being. And I'm pretty confident that those recommendations will be implemented, so there will be a recognition at law that you can't charge commission and professional charges unless you have obtained informed consent from your client. So always think about giving informed consent, signing the client up, and going through those factors that Justice Habsburger set out in Shmulevic's case. And I'm fairly confident that you won't go wrong if you do come and see me.
Can I make one comment that sort of flows from some of this discussion, which is, you've heard it said, keep your detailed notes. That's all very well. If your notes are good and you've sorted it out, they may be very helpful to deal with you should have this or you should have that. If your notes aren't good, if your notes are, they'll be trawled through to see what you should or shouldn't have done and what you've turned your mind to. I don't mind telling you I've done wills and been executor and been under challenge. My note was challenged because it says, turned his mind to capacity, queried it. I queried it and took the view that capacity wasn't a problem, but the fact that it was in my notes was then used against me. I'm thinking, well, that's how helpful is that? I've kept a note, I turned my mind to it, I thought I was protecting my back. What it came back, it says he's turned his mind to it. We now say that there was a lack of capacity for X reasons, and there had been some slightly erratic behaviour, but nothing that went to capacity in my view, but it came back to bite me. Okay, keep your notes. But if your notes are terrific, they'll be used against you because you will have thought about a whole lot of things and someone will say you're wrong. And if your notes aren't flash, they'll be used to say, well, you didn't turn your mind to things you should have. I still say keep, in expectation that you're all diligent and careful practitioners, keep your notes. But if you're not, don't want to know. John?
I suppose in the end you should put your notes, deed them away with the will.
Yes, there's a whole lot of questions about how that then unfolds. The wills file has to be produced down the track. It's 9 o'clock.
It will be destroyed.
Yes, exactly.
Yeah.
How long down before? Except we've got the position that Gavin was talking to me about. They change the will every 6 months as different ebb and flow, and you're out of the will and you're in the will, or someone tried to put me in a home and someone's prepared to look after me. Oh my God. Could we thank the speakers for what they've done, and thank you for coming. See you next year.